morning, everyone. Welcome to our first Housing Committee meeting of the year. Today is February 1st, 9:30 a.m. hearing. You're in conference room 312. Thank you for the members for being here, and thank you to the audience for coming in. It's great to be back in person. Just a few things before we begin. We have a time limit on testimony, so there's 2-minute time limit per testifier. Just because we want to get through all of our bills, and we do have to get to the floor by noon. So hopefully we'll wrap up. I don't think we've ever had a problem, and just make sure that we get through testimony fairly quickly. Please, for those that are on Zoom, make sure you keep yourself muted and video off while waiting, and turn your video off once your testimony is complete. The Zoom chat function will allow you to chat with the technical staff only, so please use the chat only for technical issues. If you get disconnected unexpectedly, you may attempt to rejoin the meeting, but please note the House is not responsible for any bad internet connections on testifiers' end. And with that, we will start with our first bill. We'll start with HB 84 relating to counties. First up, we have David Louie with Airbnb.
Good morning, Chair Hashimoto, Vice Chair Ayu, members. Thank you for the opportunity to testify, and I'll be brief. I've submitted written testimony. Basically, as a former Attorney General, I am working with Airbnb on this. There are huge concerns on this bill of a constitutional nature. This bill attempts to address the county's powers to regulate short-term rentals, but it defines short-term rentals as 180 days. Most of the time you're talking about transient vacation rentals, which is a few days or a week or maybe 2 weeks. This is 180 days. So there's gigantic problems, both on a constitutional level, which are in my written testimony. I don't want to bore you with the details, but there's huge concerns because people have been doing this for a long time, and now the counties and the state may try and take those rights away. Okay, and so you can't do that under the Constitution, and the legislature has an obligation to pass constitutional laws. So that's one thing. The 180 days is overbroad as far as what a short-term rental is on a residential basis, and so that's gigantic concern. And this is going to have unintended consequences. What about families that sell their house? They got to find something temporarily. What about workers, nurses, doctors that come in and are going to be here for 6 months or less? They can't rent a place. I mean, what if they're going to only be here 3 months? What about people who are employees, temporary employees? So those are huge unintended consequences that we think this bill has not been thought through well, and it's likely going to lead to litigation, and the state may become embroiled in litigation. So anyway, thank you. The rest of it you can see in my written testimony. I'm always happy to take questions, but thank you so much.
Thanks, Mr. Louie. Let's see, Carl Imparato, individual in support. Karen Diamond, individual in support. Kathleen Pahinui, individual in support. Stuart Simmons, individual in support. John DeFries, HTA, anyone from HTA here? Comments? And Alex April, Airbnb, with comments. Anyone else here wishing to testify on HB 84? Members, any questions?
Chair.
Raponishi.
For Mr. Louie,
Yes.
this has been an issue that has come up before. My question is there any law in the state of Hawaii that would not allow a county on their own to put in an ordinance that would address their concerns in terms of short-term vacation rentals and the length or I guess make laws that would regulate short-term vacation rentals?
Right, and so there's two dimensions to this. First, there's the Constitution, which protects people who have vested rights, who have been doing legal things with their properties, and the Constitution protects that. And then that's been codified by the legislature in 46-4. okay? And 46-4 is one of the things that some other bills have sought to amend and regulate. But you can't, it's a broad problem, and I perceive the problem, I understand the problem, and Airbnb has actually worked with the county previously and of Honolulu and reached understandings, and has worked with Kauai and has reached understandings and things like that. So you can't just do half, try and amend the statute without also amending 46-4 and also without dealing with the constitutional problems. It's a complex kind of a thing. We have concerns about this bill. This bill is kind of broad, overly broad, and we think that it creates a lot of problems. So to answer your question directly, there is a statute that provides for protections for these kinds of things. There is no statute that allows the counties to do whatever they want, because there are both constitutional protections and codified statutes about that.
Okay,
Thank you.
Thank you, Chair.
Thank you. Any other questions? Right by you.
Mr. Lee, same for you. So on the definition of public use in the Hawaii State Constitution, does it adopt the same definition on the federal level for public use, which is a public purpose?
Thank you for that, Vice Chair. I don't know the answer to that question. I do believe that the federal courts have looked at will probably look at sort of the same general cases and concerns about what constitutes a public purpose. The only thing I would say is that you can have a public purpose, but a public purpose cannot always trump easily vested constitutional rights. So that although there may be a public purpose, and that is a justification for doing certain things, and so, for example, in this case, issues of overcrowding, over-tourism, things like that might constitute a public purpose that want to be addressed, still you have to respect the constitutional rights of property owners.
Okay.
Has that answered your question? I apologize.
My second question is related to the regulation of health, safety, and welfare, which I think is clear that the legislature or the counties have the ability to regulate that. So I'm just trying to figure out how the regulation of health, safety, and welfare either relates to or does not relate to this type of regulation.
Absolutely, and I guess what I'd say is obviously the legislature always has the ability to regulate health, safety, and welfare, and obviously the legislature always has the ability to legislate in areas for public use and public purposes. But it's not unfettered power and authority to regulate. When you do regulate, you still have to make sure that you're respecting constitutional rights of people and that the legislation is in accord with the Constitution.
Okay, so if the county changes like a zoning designation for a property and does not grandfather that designation in, are you saying that that's a violation of the Constitution?
Potentially, not always, potentially. It depends on, so for example, in this particular instance, the county has allowed a lot of uses for what is now being redefined as short-term rentals of less than 180 days. And also, just the landlord-tenant code allows for month-to-month rentals. So this law, I mean, if the counties did something and said 180 days, you gotta have a minimum contract for 180 days, that's gonna conflict with the landlord-tenant code, which allows for 30-day rentals. I mean, so you're gonna have all these problems that are gonna crop up. So if the counties do certain things, they have to be held accountable to the Constitution as well.
So last question, is allowing the use the same as expressly like permitting it?
That's a somewhat gray area, because in this case, what is being asked for is for the state to enable and allow the counties to do certain things. But where the counties have already expressly attempted to do unconstitutional things that have been the subject of litigation, and this legislation enables those types of uses, those types of regulation. I believe that the state has an obligation, we've cited in here, that the state has to take acknowledgement that it has to do things that are constitutional too. It can't just turn a blind eye. I'm not gonna say the state's solely responsible in that regard. You know, it's kind of a shared responsibility. But the state has, I can't say, and I won't say that the state has zero responsibility. The state always has a responsibility to do things appropriately and in accord with the Constitution.
Thank you, Chair.
All right.
Thank you for your questions.
Thank you. Rep. Kila, go ahead.
For you, sir.
Yes, sir.
So, with you coming in opposition of the bill and everyone else in support, where is the stance of Airbnb, right? Because obviously there are some folks who have abused what this has become, and I look at neighborhoods like mine that already are very tight-knit communities, and one, they're seeing houses with folks coming in and out of their neighborhoods that are not from our community, while they're seeing homelessness on the beach. So is Airbnb aware of the issues that has come up because of the housing?
Sure, and let me be very careful here, because I am not an Airbnb employee.
Right.
I'm outside counsel for the Airbnb, and I advise them on legal issues. But Airbnb has been in this area for quite a long time, and to my knowledge, is aware of these issues. I'm aware of these issues.
Mhm.
I live in Hawaii. I mean, but let me say this. One, it's a broad problem. There have been legal uses where people have legally been permitted by the counties in Honolulu
Right.
and the other counties to rent their houses
Right.
out on a short-term basis. There are also have been a host of illegal rentals.
Right.
And I recognize that, and I'm not talking about the illegal rentals, okay? The illegal rentals, the county should be, they have the power to do that. They already have the power to crack down on illegal rentals.
Right.
And that's their thing. What we're talking about here is that this statute, it's sort of like baby and bathwater things, you know, where we'll just dump the whole thing out.
Mm-hmm.
But that negatively impacts legal permitted uses which have constitutional protections. So I guess what I want to say to you is there is a problem.
Mhm.
I understand the problem. I understand the concerns about that. But you have to use a scalpel. You can't use a sledgehammer on this problem. And this bill, unfortunately, is more of a sledgehammer.
Okay. In respect of time, can you, we'll connect offline?
Yes.
Or after the meeting?
Happy to.
Thank you.
Please.
All right, members, any
Thank
other
you, Chair.
questions? Rep. Martin, go ahead.
I would have questions if the Attorney General had weighed in, but I don't think it's appropriate to ask legal questions
Okay.
to a lobbyist for a particular side with a financial vested interest who has opposed enforcement of illegal vacation rentals in our county. But I do wish I would like to hear in a future hearing what the
Absolutely.
Attorney General has to say.
Okay. Thank you very much.
Hi, I'm sorry. I'm from the Attorney General's office. If there's questions you'd like to direct, I can take them back and get you an answer.
Okay, yeah, I would love to have them weigh in. You know, the lobbyist for Airbnb has claimed that this is unconstitutional, and we obviously didn't get any testimony to that effect from the Attorney General, so I'd love to have them weigh in. Thank you.
Thank you.
All right.
Later question.
All right, thank you, members. Let's move on to HB 329 relating to energy. First up, we have Micah Munikata, Ulupono Initiative in support. Dave Mullinex, Our Revolution in support. Sherry Pollock, 350 Hawaii in support. Melody Aduha, co-chair in support. Max Lindsay, BIA Hawaii with comments. Oh, all right. We have Paul Bernstein, individual in support.
Hi, thank you very much, Chair and members of the committee. Just would like to say I strongly support this bill because I would like other homeowners to be able to avoid the problems that I've experienced when trying to move my house to a more renewable setting. Because of the fact that it wasn't equipped or wasn't originally equipped with the ability to make these retrofits. So I think this bill would greatly save homeowners both cost and hassles and allow them to do what we all want to do, namely lower our greenhouse gas emissions. Thank you very much.
Thank you. We have Rocky Mold, Hawaii Solar Energy Association.
Aloha, Chair, and members of the committee. I'm Rocky Mold, Executive Director of the Hawaii Solar Energy Association. I'll stand on written testimony in support of this common sense measure that will save money and lower our costs to achieve our resilience and sustainability goals for Hawaii. Thank you very much. I'm here for questions if you have them.
All right. Evan Oy, NAOP.
Hey, Chair, good morning, Chair. Evan Oy, stand on written testimony in opposition. Will be available for any questions.
All right, thank you. Roy Skaggs, in support. All right, anyone else wishing to testify on HB 329? Members, any questions? All right, Rep.
Chair.
Ayu, go ahead. Oh, Rep.
Go ahead,
Onishi,
go
go
ahead.
ahead.
Vice Chair.
No, go ahead.
Okay, for Mr. Oy? My question is, the bill refers to a cost estimate that was done by the City and County of Honolulu in regards to the cost for solar conduit and electric panel readiness to range from $100 to $300 in additional costs, and the same cost for electric vehicle readiness. Do you agree with those estimate costs?
So, sorry, members, real quick. We just gotta, our tech staff is telling us we're not going close enough to the mic, so we gotta go closer to the mic, just so they can pick up on Zoom.
Okay, is that better?
Is that better?
Okay. So do you want me to restate my question?
I think we're okay.
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 Got it.
Yes. Thank you, Chair. Thank you, Representative, for the question. We would actually disagree with that, estimates in the bill at this time. I believe we did do some numbers on Coral Ridge in the past on this project, and the readiness would be substantially more in our, if I remember correctly on that. And I think this is just a general issue of costs in general as construction costs continue to rise. That's our main concern. It could eliminate housing opportunities. So, but to answer your question directly, I don't think we would agree with those numbers at this time.
Do you have any idea on what your study or information in terms of the numbers?
I would have to refer back to, I believe we have some data, but I can connect with you offline if
Okay,
you
or
would like.
can you provide it to the
To the chair
chairs
as
or
well.
vice chair?
Yes.
For them to distribute.
Yeah.
Thank you.
Thank you, Rep.
All right, Rep. Ayu.
Mr. Bernstein, are you still on Zoom?
Yes.
I just want to have an idea, how much did you spend on the improvements because the home you moved into wasn't ready? And I'm not talking about the panels itself or whatever, just talking about what we're talking about in the bill.
Actually, I never went forward with anything, and mine is a bit different than this bill. It's to do solar hot water heating. So I recognize that you're talking about PV panels. But to me, it's the same issue. I was never able to get solar hot water heating because I could never get a contractor to redo the electrical work necessary to switch out the gas hot water heater with an electric hot water heater. So hence my strong interest in seeing something like this put forward so homeowners can do things like this.
Okay, thank you.
All right, members, any other questions? All right, seeing none, let's move on. HB 670, relating to the Land Use Commission. We'll start off with Lindsay Garcia, Hawaii Realtors, in support.
Good morning, Lindsay Garcia from Hawaii Realtors. We stand in support of the bill.
All right, Ted Kafalis, Grassroots Institute of Hawaii.
Good morning, Chair, Vice Chair. We stand in support and stand on our written testimony.
Dan Ordenecker, State Land Use Commission.
Thank you, Chair, and members of the committee. You've seen our written testimony. We don't have any problems with reducing the number of votes required for a district boundary amendment. However, we don't think it's necessary. If you look at our record, almost all of our decisions are unanimous or virtually unanimous. We do have concerns with the second part of the bill, which shortens the time frame for when district boundary amendments must be completed. Keep in mind that in recent years, the Hawaii Supreme Court has held that the adoption of an order is now part of that time frame. Okay? Sometimes it takes a while to prepare the order. That being said, we're not concerned, we don't think this change will have much of an impact, but it may have some bad results. We usually complete our proceedings well within the 180-day period. We're usually 3 to 4 months completed on a district boundary amendment proceeding if it is not controversial. However, I caution that the bad results may occur in cases when you really need the Land Use Commission to complete its deliberations, such as with whole appealing. I mean, that took us a little bit over a year. We actually had to get an extension under our rules. And if that had been automatically approved, it could have been quite devastating for the community. And that's what we're concerned about. For the most part, we're done well within 180 days. But if that one really complicated and really difficult case came along, and we didn't have the full 365 days, it could be very devastating. Also, keep in mind that our commissioners are volunteers. We meet 4 times a month. We don't control our workload. Whatever gets submitted, we have to handle. That causes problems with our schedule as well. So I'm here for any questions if you have them.
Thank you. Zuri Aki, Office of Hawaiian Affairs. In opposition. Anyone else wishing to testify on HB 670? All right, members, any questions? Rep. Todd.
Hi, I have a real quick question for Land Use Commission. Thank you. This may be a long shot, but in section 3, so basically the first area, section 3, and it's 1B, where it eliminates language that says the commission shall within not less than 60 and not more than 180 days, and it amends that to just within 120 days. Do you know why we have language that would not allow a hearing within the first 60 days to start with?
Yes. The practicalities of that arise from due process. All our hearings on district boundary amendments are contested case hearings. In order for the parties to prepare for contested case hearings, they must, the petitioner first must submit its position statement, which evolves from the petition. The Office of Planning and Sustainable Development and the county and any interveners then must file a response briefs with their position. And then after that, once that's completed, then there needs to be a filing with regard to witnesses, witness lists, and evidence and exhibit lists. Unfortunately, because the Office of Planning represents the entire state, when it gets a petition, a completed petition, it must distribute it to all the other agencies for comment. That includes the Department of Transportation, the Department of Education, and various other agencies, depending on the nature of the permit being requested. It takes them a period of time to get those responses back. They require 60 days. They will tell us always, we need 60 days to get our responses back. It also, that 60-day period, if you look at our rules, also takes into account the notice requirements that have to be published in the newspaper and to the community so that they can prepare for the hearing and decide whether or not they want to intervene. So it's really a due process issue that prevents immediate hearings.
So are there any situations where you've had these petitions and you've been prepared within the first 60 days? Or is it just always, just due to that process, going to take more than 60? Just out of curiosity.
Yeah. There have been,
rarely maybe?
Well, keep in mind, 201H projects are different because we only have 45 days, but most of that takes place at the county level, and then we get it afterwards, after it's completed. So affordable housing is a different story. We have to do those within 45 days. But even that is kind of impractical because what happens there is that because of the short time frame, the parties actually prepare their position statements and submit them to us and prepare their witness and evidence lists before the petition is actually completed, because otherwise it can't We have had situations where the petition is very, very simple and very straightforward and well vetted through the Chapter 343 process, the environmental impact statement process. And in those instances, we have been prepared earlier than 60 days as far as the parties' due process issues are concerned. What prevents us from hearing within that first 60 days is the notice requirements to the public and the ability of interveners to come in and request time.
Great, thank you.
Okay. Members, any other questions? Thank you. Thanks,
Thank
Dan.
you.
All right, seeing no other questions, we will move on to HB 497 relating to housing. First up, Chad Keone-Furious, School Facilities Authority.
Yep. Hello, Chair. Chad Keone-Furious, School Facilities Authority. We stand by our testimony in support of this organization. We're available for questions.
All right, thank you. Sterling Kiga, Housing Hawaii's Future, in support. Laverne Moore, HSTA.
Aloha, Laverne Moore, HSTA teacher lobbyist, speaking on behalf of Osa Tui, President of the Hawaii State Teachers Association. We strongly support this bill, and we do have our written testimony, but I want to point out the key fact that we have a severe teacher shortage. Without housing, there is no way we can get teachers to staff our schools. And with the preschools coming on, this is even going to be greater. And from our report, Kauai, you cannot even find an affordable rental. Maui, you cannot find an affordable rental. Hilo, you cannot find an affordable rental. So there is no rental for our teachers. Even if they could pay for it, it's not there to be had. And this is a good start to look at the possibility of changing Liliuokalani into a facility that can do preschool, do office, and housing for our working class and our teachers. Thank you.
All right, thank you. We have Zizi Zhang of CARES in support, and Lori Yamada in support. All right, anyone else wishing to testify? HB 497. Members, any questions?
Sure.
Onishi, go ahead.
Yeah, for Mr. Frias. How's it? How you doing?
Good. Good morning.
Welcome to Oahu from the Big Island. I know you're here pretty often, but, so my question is, what is the DOE doing, or not the DOE specifically, but more your, part of the, facility development doing in regards to teacher housing on DOE property?
Yeah, so the SFA, and thanks for the clarification, working with the DOE, trying to identify all usable sites for these types of projects
So you're looking statewide.
statewide.
So what would make sense would be for us to help you fund your statewide assessment, so that, as HSTA mentioned, that you can look at projects throughout the state on DOE property that would be able to be improved for teacher housing.
Yeah, absolutely. So to answer that question, we would be still in strong support if this broadened the scope, if
Thank
this
you
bill
very
broadened
much.
that scope. Any other questions?
Members, Rep. Martin.
I'm curious, I'm very supportive of this, but do we need a bill for this? Or do we need to set a precedent for other school locations to be considered as well? Or what are other ways? I'd be interested in doing this. I'm curious, does it require legislation? Or would having this bill go through set a precedent, which means that other projects could go through without legislation?
Yeah, I believe the authority is granted to the School Facilities Authority to do this type of work. We support this bill for the feasibility study to bring more data to ensure that we can get this project done. But I hear your concern about the precedent setting, yeah.
Members, any other questions? Vice Chair.
Have you guys looked at this property yet and considered anything, or what actually do you need to do as part of the feasibility study to decide to move forward?
So we physically looked at the property and looked at the TMK and looked at the area. We haven't gone in to look at the density and, all of that stuff, or even gone out to community to do any type of charrette, but we did physically visit and had some preliminary conversations with the DOE, some other representatives that brought it up to our attention.
Members, any other questions? I do have one question. So when you take a look at this type of study, what do you need? What is the amount that you need to actually get this done, to get you started?
I don't know the amount. I really don't know an actual amount, especially if we're doing what Rep. Onishi wants to do and increase this feasibility study from Kauai to Na'alehu.
Okay. So,
Yeah.
so you haven't done any inquiries on how much a statewide study would be either?
Not a statewide study. We haven't really done even a single study to look at one site, but we could start that
Okay.
on a single site and then try to scale it from there.
Okay.
Mhm.
Members, any Rep.
Sure,
Onishi?
I have a follow-up.
Okay.
So, to address Rep. Martin's concern, right, I believe that on Maui,
Mhm.
at, is it Lahaina Luna?
Lahaina.
There's a project that's already being developed
Yes.
for teacher housing on Maui. So, but wasn't done by you, right? It was done by DOE facilities?
Yes.
Yeah, okay, so there is already the DOE's consideration of looking at development of teacher housing.
Right.
Okay, thank
Right,
you.
and to your point, the zoning laws in different counties are very different, makes the price point per unit considerably different.
Yeah,
Yeah.
okay.
All right, members,
Thank
any
you.
other questions? Thank you, Mr. Freeze.
Thank you.
Thank you for being here. All right, seeing no other questions, let's move on to HB 567 relating to the Department of Hawaiian Homelands. First up, we have Luis Salaveria, Department of Budget and Finance, with comments. Chad Keone Furious, School SFA, with comments.
We stand by our testimony.
Gary Suganuma, Director of Taxation, Department of Taxation.
My name is Brian Davidson. I represent the Department of Taxation. We stand on the comments that we provided.
Okay, thank you. Ikaika Anderson, Chairman Designate, Department of Hawaiian Homelands.
Good morning, Deputy to the Chair, Keely Ducat, and we will stand on our written testimony and support and are available for any questions.
All right. Tom Yamachika, Tax Foundation of Hawaii. Oh, I think he was there, now he's gone. All right, but he has comments as well. Members, any questions? All right, this is a big bill, but seeing no questions, oh, Rep. Matsumoto.
So correct me if I'm wrong, it removes the deadline for the 600 million that we appropriated last year. Do you have any comments on that?
So 567 does remove the deadline, but our testimony would like to have this committee consider inserting the language that is in HB 1507, which basically, and there's been a lot of talk about whether or not it's an extension. We don't believe it's an extension. What we're trying to accomplish by this legislation is to submit language that would make it so that DHHL has until June 30th, 2025 to encumber the funds. Right now, that the way that it works is that because of the biennium and because of the constitutional limitations, even though the bill technically says June 30th, 2025, in effect, we only have until June 30th, 2024. And so we believe that the language of HB 1507 is a better way of getting to that intent. Thank you.
Okay, members, any other questions? All right, seeing none, we'll move on to HB 280 relating to property. First up, we have Miranda Steed, Deputy Attorney General, with comments.
Good morning, Mr. Chair, committee members. Thank you for having us here today. We would like to first note that we appreciate the aims of House Bill 280 in addressing the affordable housing issues in this state. However, we do respectfully request that this committee hold this bill just because of the fact that it raises numerous constitutional violation issues that would be very likely subject to litigation and we're not convinced that it would pass constitutional muster if it were subject to those to that litigation. We have enumerated in our testimony the different constitutional issues we think this raises. I am here for questions if committee members have any further questions regarding that. Thank you.
Thank you. Lindsay Garcia, Hawaii Realtors.
Thank you. We stand on our testimony.
Okay. Thank you. Kathleen Pahinui, in support. Ryan Ozawa, in support. Zuri Aki, Office of Hawaiian Affairs, in support. Anyone else wishing to testify? HB 280. Members, any questions?
I have a question, Chair.
Rep. Kila.
For the Attorney General's office. So I understand the concern when it comes to constitutional amendments, but my concern with the department is that when you folks comment like that, there was no attempt to see what we can do to make it technically amended in the sense of achieving the goal, right? So I just, I was looking for to assist how we can make the bill fall in line with some of the regulations that you folks had shared concerns of.
Yeah, I completely understand that. And these are, difficult to address because there are so many. What I would first note is that, if I may just address a couple of the constitutional issues. The first one that we noted was the Dormant Commerce Clause. Because because prohibiting property that deals with foreign investors would protrude on the federal government's foreign commerce powers. This would trigger scrutiny under the Dormant Commerce Clause, which is subject to strict scrutiny, meaning that to overcome that challenge, it would have to be demonstrated that this law has a compelling legitimate government interest that is also the least restrictive available means for achieving that said interest. And so that's a very, very high burden. And I'm not saying that it's impossible for it to ever reach that, but as currently written, I don't think that it would necessarily pass constitutional muster. I did note in the bills, in the explanation for the bill, it was noted that there were applicable Oklahoma or related Oklahoma and Wisconsin statutes. We don't know the constitutionality of those statutes because they've never been challenged in federal court before. So the questions raised by this bill are currently unanswered by the federal court system, which would be likely the area this would be challenged in, as it's a federal constitutional issue. There's also similar issues raised with privileges and immunities under the 14th Amendment. Because this specifically deals with persons as well, not just corporations, privileges and immunities could apply because we're talking about specifically taking away property from an individual. Even though we're talking about aliens, they are subject to constitutional protections as well under certain circumstances, such as potentially in privileges and immunities. Finally, I would note there's also an issue under equal protection because we have identified a class of people. This would likely, again, arise to strict scrutiny. And there's also, and I apologize for the plethora of issues I'm listing, there's just also an issue under the Takings Clause. Now, I know raised earlier with another House bill, there's a question of what is public purpose in the U.S. Constitution versus the Hawaii Constitution. What I would note is that they are substantially similar. There have been a couple Hawaii cases that have interpreted the public use versus public purpose under our state constitution, Article 1, Section 20. And what I'm specifically referring to is a Hawaii Housing Authority v. Lyman and also County of Hawaii v. C.J. Coop family. Both of those, what the court found was quite frankly substantially similar to what what the Supreme Court has held under the Fifth Amendment Takings Clause, which is that unless a taking is pretextual predominantly for a private purpose, it is probably constitutional. However, the question that does raise is that this bill doesn't address what exactly happens to the property after it's taken. And presumably, my understanding is that you're addressing affordable housing. So presumably you'd want to take it for some kind of public purpose, but that isn't articulated in the bill. And it needs to be clarified what would be happening with that property. Otherwise, we do run into, well, what if it is being handed over to another private developer? Maybe that's constitutional, maybe it's not. It's unclear. So all this is to say is that we do appreciate the aims and attempts. And I think that this is an issue that does need to be addressed in the state. we're just not convinced that this is the right means to do it, just because of the number of constitutional issues. I'm sorry for my long-winded answer.
No, I appreciate how much research you did in regarding to the bill. So in the case that the bill is held, I would love to see more conversations from your folks' side that we can address the issues that we're facing, right? And it's no knock against folks that want to do business here in Hawaii and are seeking property. But as I share with others, we're looking for the best chance to give people here in Hawaii the chance of home ownership. So we're looking for every avenue possible under the clauses that we fall under the United States Constitution. So I would love to see if that's the case, we can work on conversations offline. So thank you.
Absolutely, and you know, our office is available. You're welcome to reach out to us and we can have those further conversations. And you know, we appreciate the work that you folks are doing on these issues as well. Thank you.
Thank you, Chair.
All right, Mal, right by you.
One
Go
more,
ahead.
one more question, Deputy Attorney General. My question is the legislature allowed to favor in-state residents for like affordable housing, or are we allowed to give preferential treatment for in-staters versus out-of-staters?
Okay, so for in-state versus out-of-state, most likely no, that's not possible. And the reason for that is that under the 11th Amendment, we're not allowed to discriminate versus in-state, out-of-state. So this same issue arises when we have bills that come forward regulating like commercial fishing, for example, where we want to issue a permit to fishers that maybe focuses on in-state fishers versus out-of-state fishers. We can't do that because it's commercial. The only exception really comes up when you have a recreational use. The recreational permits are considered not subject to that, but housing would likely be considered subject to the protections, so it would be considered discriminatory and likely struck down on its face. But that being said, the department does recognize like these are pressing issues. So to the extent that you have more questions on that, we would recommend that you reach out to us and have that conversation.
Thank you.
Thank you.
All right, members, any other questions? Seeing none, we're going to recess for decision making. Recess. Members, coming back in for decision making. So bear with me. There's, I think most of them are straightforward. There's one that's a little longer. So we'll start with HB 84 relating to the counties. So I think we're really going to keep this conversation moving. I think there's some big discussions happening with this. We take the consideration that of the testimonies very seriously. I think if you talk to the Attorney General, they probably may give you a different answer. So we want to get to the bottom of this and just move this to the next committee. With that, we're going to blank on page 6, line 17. We're going to blank out the 180 days based on the conversations that we've had. We're also going to defect the effective date to July 1st, 3000, and we'll make technical and non-substantive revisions. Members, any questions, comments, concerns? Right, Vice Chair. Oh, go ahead.
Chair, I just have concerns that the counties have not, in effect, really focused and enforced their county ordinances. And I do believe that non-conforming use is a county issue and the county can address it. So I have a problem with giving the counties a blanket authority to make, these types of decisions. So on this bill, I'm going to be voting no at this point.
All right. Members, any other questions, concerns, comments? Seeing none, Vice Chair for the vote.
Members voting on HB 84 with amendments. Chair elects to pass with amendments. Chair and Vice Chair vote aye. Representative Kila.
Aye.
Representative Kitagawa.
Aye.
Representative Martin.
Aye.
Representative Onishi.
No.
Representative Todd.
Aye.
Representative Matsumoto.
Aye.
Chair, your measure is adopted.
Thank you, members. Moving on to HB 329 relating to energy. So I think this one, we want to also keep this one moving. I think some of the language, you know, we took a look at it. I think there was some questions about it, but I think the introducer kind of explained to us that the language tries to conform to what the city is doing. So we'll leave that intact for now. We'll defect the effective date to July 1st, 3000. We'll make technical and non-substantive revisions. Members, any comments, concerns?
Chair?
Go ahead.
Sorry, but, you know, again, I also don't believe in the city's estimates on the cost, the additional costs. And given the fact that we may get more information from the industry as to what they estimate to be the true costs of putting in these improvements onto a building. And, you know, the legislature has, for the last, at least the last decade, been talking about affordability of housing, and yet we continue to add these requirements to housing development that just continues to increase the costs. So until we get more information on the actual impact, I want to vote with reservations.
Okay, thank you. Noted. Reservations for Rep. Onishi. Members, any comments? Go ahead, Rep. Martin.
I wanted to comment that this bill, basically the exact same provisions went into effect in 2020 in Honolulu County. And that's when the city was doing their analysis of what the actual cost would be. And the industry had thrown out some costs, which they went through and found to be very inaccurate. The real reason for this bill, actually where it started, was industry. D.H. Horton actually recommended that we do a bill like this when they were testifying against a different solar bill in the past, saying that they already do this. This is for single-family dwellings and for duplexes, which are generally not our affordable housing. But even if they were, this is such a small cost during construction that would allow our low-income residents to participate in and benefit from using renewable energy. So I think even though this probably will not impact affordable housing, this kind of preparation would only help people that live in affordable housing. Thank you, Chair.
Thank you, Rep. Martin. Members, any other comments, concerns? All right. Seeing none, Vice Chair for the vote.
Members, voting on HB 329 with amendments. Chair elects to pass with amendments. Chair and Vice Chair vote aye. Noting the with reservations from Representative Onishi. Are there any other members voting nay? Seeing none, are there any other members voting with reservations? Seeing none, Chair, your measure is adopted.
Thank you, Vice Chair. Moving on to HB 670 relating to the Land Use Commission. I appreciate the testimony from the Land Use Commission. So with that, we're going to delete Section 3, number 1 and number 2. We're going to defect the effective date to July 1st, 3000, and we're going to make technical and non-substantive revisions. So Section 1 and 2 is the time limits, members. Any questions, concerns, comments? All right, seeing none, Vice Chair for the vote.
Members voting on House Bill 670, excuse me, Chair elects to pass with amendments. Chair and Vice Chair voting aye, and noting the presence of all other members, are there any members voting nay? Seeing none, are there any members voting with reservations? Seeing none, Chair, your measure is adopted.
All right, thank you, Vice Chair. Moving on to HB 497 relating to housing. This is the study that is requested for the site at Queen Liliuokalani Elementary School property. We are going to defect the effective date to July 1st, 3000 to continue the discussion. We're going to make technical and non-substantive revisions. In the committee report, we're going to note that the study should cost about $100,000. I went to ask HHFDC for an estimate, and that's the estimate that they're giving for the cost of the study, to include project design, planning, traffic studies, community outreach, utilities, and sewer assessment. So we'll move that forward, and we also put in the committee report that we recommend looking at a broader statewide plan for SFA developments. Members, any questions, concerns?
Quick comment.
Rep. Todd, go ahead.
I'll be voting in support, but I would echo some of the comments that were made when we were actually hearing the bill, which is, it is a little bit odd for us to be identifying a very specific property. I do appreciate the need to appropriate funding for feasibility in general, but notably, as a neighbor islander, housing tends to be much cheaper in East Hawaii, so we could definitely build a lot more units. So it is odd to identify a specific property within the urban core where it would probably cost us more money per unit anyway, but just thought I'd make that comment.
Thank you, Rep. Todd. Rep. Martin.
I just want to comment that I do appreciate that the introducer of the bill has done a lot of groundwork, and that property is ready to go, as opposed to other properties which may not be ready for that step yet. And so I would hate for us to undermine efforts taken by somebody to try to improve the situation, while still noting that we would like to have much more of this.
Thank you, Rep. Martin. Any other questions, comments? Vice Chair?
Chair, I do want to express the same sentiments as Representative Todd, that I strongly support this. I just want to see a lot more of it. I just hate that we have to wait for session or legislation to make it happen. I'd just like to see it happen automatically.
Great. Any other questions, comments, concerns? Seeing none, Vice Chair for the vote.
Members, we're voting on House Bill 497. Chair elects to pass with amendments. Noting the Chair and Vice Chair vote aye. Noting that all members are still present, are there any members voting nay? Seeing none, are there any members voting with reservations? Seeing none, Chair, your measure is adopted.
Thank you, Vice Chair. All right, moving on to HB 567, relating to the Department of Hawaiian Homelands. This one's the one where we're going to have to explain a little bit. So I think we are close to a bill. We're going to continue the discussion. So we're going to defect the effective date to July 1, 3000 and allow staff to make technical and non-substantive revisions. But with that, we made our best effort in trying to fix this bill as best as we can so that we're close. It's not perfect, but we're close. So what we're going to do is we're going to replace Part 1 with the contents of HB 1055, which is the GOVS package, DHHL, GET exemption. And so parts 1 to 3 of that bill gives specific conditions of when the exemption applies, including definitions for rehabilitation. So I think those are good amendments. And so we want to make sure to add in, though, within HB 1055, we do make clear that it's for when new units are created. And that is the intent of the GET exemption. So we'll make some clarifying amendments to 1055 to make sure that is also clear. In 1055, there is also an amendment where we are going to add in any qualified person definition from 567, because 1055 didn't have that definition of any qualified person. So we're going to take that definition and leave that in the bill. And we're going to, under Section 2, Part B, in 1055, it says the exemption eligibility shall be approved, and we're going to add the word or denied by the Department of Hawaiian Homeland. So this is the GET exemption. They said when they want to make sure they screen the eligibility for GET exemption. So it says you can be approved, but it doesn't allow them the ability to get denied. So we want to make sure we add that in. So that's the GET exemption in Part 1. Part 2, we're going to conform the school impact fee exemption to the existing law, because in 567 it wasn't the existing law. So we're going to make sure it conforms, and we're actually going to try and make that permanent. So in the bill, it's going to delete any references to sunset. We're also going to make sure that although it's implied, we're going to make sure it's clear that the exemption is for new units where it's created to utilize the school impact fee exemption. In Part 3, we're going to take the contents of HB 1507, which is a Gov package bill from DHHL. So this is a little tricky. So this is to allow them to have an extension of the 600 million. And so we're going to leave that in for discussion purposes. But I think what is in 567, according to the Attorney General, does not work, because we cannot legislate past the biennium. So essentially what HB 1507 does is it allows us to force lapse the appropriation and reappropriate to 2025. So that's the correct way to reappropriate and give them an extension. So we're going to add the contents of HB 1507, which does that, into Part 3. Part 4 relates to the permanent housing credits of Act 80, 2019. So we're going to allow them to use those housing credits, and we're going to remove the sunset date. So we're going to make that permanent as well. It's also implied that it's the credits are to be used for only new units, but we're going to clarify to make sure in the language it is only for new units. As I said before, we're going to defect the effective date and allow staff to make non-substantive and technical revisions. So that's a lot, members. So if you have questions, please let me know and we can try and explain it. But this is the omnibus bill. This is what we're moving out for DHHL. And so we're taking all the bills that were separate and it's all in one. And so this should be most of what they wanted. We didn't put everything, but it's most of what they wanted, I believe. Members, questions, concerns?
I have a comment.
Okay, Rep. Kila, go ahead.
I just want to appreciate the work of you, Chair Hashimoto, to make the viability of us supporting Department of Hawaiian Homelands. As I've constantly said, by solving the affordable housing crisis is by housing Native Hawaiians. So when we take actions like this on the committee to make it easier for the department to operate, to fulfill their judiciary duties, I just can't help but be grateful. So thank you, Chair.
Absolutely. Rep. Onishi.
Chair, I just have concerns about the exemption for school impact fees. You know, especially for new development, if you're adding, you know, a multitude of homes, and especially if you're gearing towards affordable homes and families, that's gonna have a huge impact on potential schools as well as traffic. So it's just my concern that I think that there has to be more guidance in terms of when an exemption applies and how it impacts the school. You know, there has to be some criteria as to whether or not, who's gonna fund the improvements to the schools.
Absolutely.
That are necessary. Whether we're taking on that responsibility or the development needs to take on that responsibility. So, it's just a concern I wanted to raise.
Yeah, no, I think that's a great concern. I think school impact fees in general is a concern. I think, you know, most counties pay it. I think the County of Hawaii doesn't. So that's in itself a bigger issue. So I think this issue of school impact fees should be looked further into. Maybe we'll note that in the committee report that school impact fees should be looked at into further. So good point, Rep. Onishi. Any other questions, comments, concerns? Seeing none, Vice Chair for the vote.
Members, voting on House Bill 567, Chair elects to pass with amendments. Chair and Vice Chair vote aye, noting that all members are still present. Are there any members voting nay? Seeing none, are there any members voting with reservations? Seeing none, Chair, your measure is adopted.
All right, thank you, Vice Chair. Finally, last bill, HB 280, relating to property. We're going to defer this measure. And with that, members, we are done with our agenda, so we will adjourn. Thank you, members.